right, good afternoon, good evening, good morning, as the case may be, and welcome to the Legacy of Lawrence. It's a Black History Month celebration presented by the Black LGBTQ plus Legal Professionals Caucus. Now, the caucus is a joint endeavor. It began back in 2021, and it involves the National Bar Association's LGBTQ plus division and the National LGBTQ plus Bar Association. It's a networking and supportive space for Black and LGBTQ identifying lawyers, judges, law students, and paralegals and other legal professionals. For those of you who I haven't had the pleasure of meeting, I'm Travis Torrance, and nothing gives me greater pleasure than serving currently as the president of the National LGBTQ plus Bar Foundation, especially during Black History Month. And remarkably, my co-president, the president of the association side of our organization, Bendita Cynthia Malakia, is also Black. While Bendita isn't joining us tonight, I am extremely excited because I am joined by a panel of lawyers who represent a dynamic tapestry of experiences. They represent a dynamic tapestry of perspectives, and they represent a dynamic tapestry of backgrounds and identities. And we are going to have a really robust discussion about the legacy of the Lawrence decision and specifically Tyrone Garner, a key plaintiff in the case. Tonight, I'm joined by Eric Polk, the Chief of Staff at ProGeorgia, Brianna A. Jenkins, the Policy Director at Lavender Rights, and last but not least, Nneka Elanu, a staff attorney at American Civil Liberties Union of Georgia. Now, instead of reading their bios and telling you all about their impressive work, what they've done, and their credentials, let's hear it in their own words. So, Eric, if I can turn to you first, why don't you kick us off? Tell us about your background, your work experience, and what's currently happening at ProGeorgia.
Absolutely. Thank you so much, Travis. Good evening, everyone. I'm Eric Polk. As Travis mentioned, I'm currently the Chief of Staff at ProGeorgia. ProGeorgia is Georgia's progressive C3 table. We represent about 61 organizations across the state, really in an effort to make sure that we are able to remove any barriers from folks to have their right to our democracy through voting. Previously, I was at Lambda Legal, where I was actually a Tyrone Garner Fellow. And so the Garner legacy is really important to me. Really happy to be here with my colleagues today to talk about really the impact of Tyrone Garner on us as legal professionals and how we can think about his legacy really as a testament to bravery in the face of adversity. And so I'll turn it back over to you, Travis.
Thanks so much, Eric. It's great to work with you tonight. Nneka, would you like to go next?
Sure, thanks so much. Hey y'all, my name is Nneka Ewolanu. My pronouns are they, them, and I am a staff attorney with the ACLU of Georgia. The ACLU of Georgia is a nonpartisan nonprofit committed to defending and enhancing the civil rights and civil liberties of all Georgians. As a staff attorney here, I litigate LGBTQ rights, but also reproductive rights, racial justice, and the First Amendment. And I'm really excited to be a part of this panel, and thanks for having me.
Thanks so much for being here. Brianna, that leaves you.
Hello, my name is Brianna Jenkins, pronouns she, her, hers. I am the policy director at Lavender Rights Project. Lavender Rights Project is a Black trans-led organization based in Seattle, Washington, where we really engage in advocacy on behalf of the trans community in the Seattle-Tacoma area. We've recently started to expand and getting more national movement work. And we really prioritize Black and Indigenous trans folks, really to elevate the conversation of transgender civil rights and make sure that everybody is impacted by policy that centers the most marginalized in the trans community.
Wonderful. Now, right before we started, Eric and I were talking about how I live in Houston, Texas, just about 45 minutes away from where the facts that gave rise to the Lawrence decision occurred. Eric happens to be in Houston tonight. He did not tell me that he was going to be here, and I'm still mad about that. But for those of us who, like me, you graduated from law school back in the early 2000s, you haven't read the opinion in a while. Nneka, can you tell us about who Tyrone Garner actually was and what were the facts of this case?
Absolutely. So Tyrone Garner was a Black man who was one of the plaintiffs in the Lawrence v. Texas case. And so at the time of this case, there were still 13 states that had sodomy laws on the books. So laws that criminalize sexual interactions, typically between same-sex folks, but sometimes they had no gender specifics to them. Tyrone Garner was a Black man. A lot of people don't realize that there was an interracial couple at the center of this case and this movement. And a lot of people frame Lawrence v. Texas as a story about, two gay lovers who were trying to have an intimate relationship, when in reality, Lawrence and Garner weren't intimately involved, at least allegedly. Garner was actually in a relationship with a different man named Eubanks, and all three of those men were hanging out at Lawrence's apartment. Eubanks thought that Garner was flirting with Lawrence, and so Eubanks left the apartment and made a false 911 call to the police saying that a gun had been brandished in the apartment. So that is why cops in Texas burst into this apartment. Previously, before this, very few people had actually been, incarcerated or arrested for sodomy laws, because it's not very often a policeman is in your bedroom. But because of this false 911 call and because of some of the erotic art and same-sex art seen on the walls, the police officers arrested Lawrence and Garner with a deviant sexual intercourse, which was the sodomy law on the books at the time. A lot of experienced gay rights lawyers in the area and in the movement didn't want to take their case. Everyone, I think, saw the potential for this to be a major impact litigation case, one of the few instances of same-sex intimacy being criminalized that could actually be used as impact litigation. But a lot of people saw an interracial couple that was middle to low income, that lived in a seedy part of town, and simply didn't want to deal with it, wanted to wait for the quote-unquote perfect plaintiff. And on top of that, both Lawrence and Garner kind of just wanted to say, didn't want to plead guilty to it, wanted to plead not guilty, wanted to fight it. And the movement lawyers at the time wanted them to plead no contest. In the end, Garner and Lawrence ended up pleading no contest, agreeing to representation. And while the attorneys tried to guarantee them some privacy, they recognized that they were going to be part of a major landmark case one way or the other. And so a case that is always talked about being between, two male lovers who just wanted to have private relations, was kind of a lot more strategic than people seem to realize or give credit to, and really shows how a lot of impact litigation takes strategy and not just happenstance.
Indeed, and I want to bring you in here, Brianna, because in 2004, the Houston Chronicle quoted Tyrone Garner as saying, "I don't want to be a hero, but I want to tell other gay people to be who you are and don't be afraid." That quote speaks volumes because we know it takes an immense amount of bravery, it takes an immense amount of courage, it takes an immense amount of sacrifice to be a named party in impact litigation. Can you talk more about that aspect?
Sure. So once you are a named party in impact litigation, you kind of open yourself up to critique, especially somebody that comes from a marginalized community. And I think we can appreciate in the times that we live in now, privacy and discretion. Everybody wants it. Especially for those of us who are already on the margins. We need as much safety as we can, because when you put yourself out there, when you name, for instance, if you're named in a case of this nature, you are open up to attack, you're open up to critique, you're open up to criticism. And a lot of times, particularly in this case for a Black gay man, there are not a lot of social supports or economic supports where we can isolate ourselves from that. So we feel and we experience everything. And oftentimes, when these cases go through their process, which typically for a Supreme Court case can take years to conclude, usually the person named in the suit doesn't really experience the benefits of the outcome of the case. So, fo- while folks might want to bestow, oh, this, you're a hero and you're doing all of these things, a lot of people who are powerless and trying to regain power give up a lot to be the face of the movement. And oftentimes on the back end, they don't really get to reap the benefits. So I think looking back, we as a community have to, in addition to finding the perfect plaintiff, working with plaintiffs over a long period of time, we also have to make sure that we have communities of care for the people that are in these cases, because folks are still living their lives throughout these cases, and they're also still will have to live their lives at the conclusion of these cases. So we really have to make sure that as lawyers that we are concerned about the lives that our plaintiffs lead, and doing what we can to make sure that there's a ecosystem of care, because it does take a lot to be visible, especially in a high profile case like this one that happened even long ago, but even more so now, just with social media and the right and just how they can attack you. I just think we should be very mindful of that.
Now, Eric, I feel like a law school professor when I ask this question, but I feel like we need to tie a bow on briefing the case, and some of us might need a refresher. But what was the specific holding of the case, and what was the court's rationale?
Yep. And so it was a 6-3 opinion. It was delivered by Kennedy. And the court essentially held that the Texas statute making it a crime for two people of the same sex to engage in certain intimate sexual conduct violates the due process clause. The court reasoned that the case turned on whether Lawrence and Garner were free as adults to engage in private conduct in the exercise of their liberty under the due process clause. One of the immediate effects of the court's ruling was that it invalidated all 13 of the existing state anti-sodomy laws, regardless of whether it applied to same-sex couples only or to all couples, both heterosexual and homosexual. Had the court issued the more narrow ruling around equal protection grounds, which was favored by O'Connor, the effect of the decision would have been that it would have invalidated only in those states where the statute specifically discriminated against LGBTQ people by prohibiting homosexual sodomy exclusively. And so since the court issued the broader ruling that the government can't criminalize private consensual adult sexual behavior, the Lawrence case created a more expansive right to sexual privacy that prohibits states from making sodomy a crime for anyone, either both straight or gay.
That's right. And I want to get to the impact of the case in a second, but one of the things that stuck out to me was that the Lawrence decision overturned Bowers versus Hardwick, which was decided back in 1986. And At the time, the story goes that Justice Powell told people that year in 1986 that he had never met a gay person, when in fact he had a gay law clerk during that term. And for 6 consecutive terms in the 1980s, he had a gay law clerk. In 2003, I don't think that any justice could say that he or she had never met a gay person. And I think that that speaks a bit to the power of visibility and what visibility can have on influencing people's perceptions. So as you alluded to, the impact of the opinion itself it was huge because the criminalization of sexual orientation impacted people's right to vote in some jurisdictions. It impacted the right to have a driver's license in other jurisdictions. It could be punished by fines in some places, and it could lead to a life sentence in others. But Nneka, turning to you, how did it impact other subsequent cases that later came to the court?
Yeah, so I think Lawrence is one of the really seminal privacy cases that I think underpins a lot of our substantive rights litigation these days. So where I see it come up a lot is in the abortion context, where Lawrence and a lot of the other, Griswold and other cases before it, kind of make this bedrock of what does privacy under the 14th Amendment look like. And that really was informative in the abortion context when abortion still had a home under the 14th Amendment prior to Dobbs. And I think it also, in general, gave a lot of lessons to impact litigation, like, again, showing that you don't always need the quote unquote perfect plaintiff. Like, if the facts and the law is on your side, it's still worth pursuing a case, even if it's not, a white cis-het couple with a perfect house and a white picket fence and what have you. People's real lived experiences have value and matter. And so we shouldn't shy away from sharing those experiences just because they don't fit the mold we're looking for. And I think it also shows how quickly precedents can change. Like you mentioned, this case, Lawrence v. Texas, overturned Bowers v. Hardwick, and the Dobbs decision overturned June Medical that happened just a couple of years before that. And so it shows, for whatever reason you want to ascribe to it, how quickly opinions on the court can change, and how just because you have a loss doesn't mean that it's the end of the road. In 5 years, 10 years, 20 years, you never know if a new argument or even the same argument might just be effective.
Brianna, anything to stack on top of that? How did the Lawrence decision impact other jurisprudence?
It's definitely evident that this particular decision signaled a changing public opinion or public awareness about gay people. And we can trace the lines in the Supreme Court subsequent decision invalidating the Defense of Marriage Act, to the decision that permitted same-sex marriage, even to the decision that showed that LGBTQ people are protected under Title VII. There's just, in addition to stating that that LGBTQ folks are entitled to private rights, it does show that that there's just a general awareness that LGBTQ folks do have the right to live dignified lives, and they're entitled to dignity both privately and as public citizens of the United States. And you can clearly see Lawrence v. Taylor cited in a lot of the seminal LGBTQ cases that were later on decided by the Supreme Court in the following years after Lawrence.
Yeah, it's interesting because Lawrence Tribe described the case as one that may well be remembered as the Brown v. Board of Education of gay and lesbian America. His words, not mine. And I imagine if you're presumed to be a criminal, that impacts your ability to get jobs. It impacts your ability to get married. It impacts your ability to get custody of kids and to adopt kids. But underpinning all of that it also affects how people view you in society as inferior, potentially, or less than. Brianna, sticking with you, how has the case impacted LGBTQ plus equality beyond, the case law and jurisprudence?
For me, I think we really have to go back to the facts of the case. And I think with the awareness that we have now and just looking back at the facts, I feel like this was even though it's not directly, it's it magnifies the racism problem that we deal with in the LGBTQ community. It magnifies how even in our LGBTQ community, we can use the police to weaponize them against people, particularly Black LGBTQ folks. And it really makes me wonder how we have like reckoned with that. And I can say that within the past 5 years, we have had more racial justice conversations in the LGBTQ movement. I think we need to have more of those conversations in the trans movement. But rereading the facts and just having the awareness that I have now, I do think there is a underlying racism component, an underlying police component that I feel that we can do both, and we can acknowledge Lawrence as the seminal LGBTQ case, but also talk about the other more quiet parts if we are really going to learn the lessons that we need to learn from Lawrence v. Taylor, in the hopes that we can acknowledge it so we don't repeat it. Because I'm also reminded of how the police, when we think of HIV criminalization, how the police are also a tool to report on folks living with HIV, to report them to the state. And you run into the same situation, and we're also having parallel conversations about how to invalidate HIV criminalization laws, not only because they are outdated, these laws are outdated, but when you have a criminal conviction under HIV laws, like you did under sodomy laws, it creates collateral consequences for you across your life where you're not able to have a good quality of life. And I'll leave it there.
Eric, same question to you. How has the case impacted LGBTQ plus equality beyond the case law, beyond the jurisprudence?
Yeah, I agree with a lot of the points that Brianna's lifted up. I think that there's definitely this piece around, I think, the case really allows for us as LGBTQ folks to really imagine our lives in a different way. A life that includes the real recognition of our humanity, of our fullness and the depth of our lives and our experiences as members of society and our communities. And so I think that the case definitely did that. I think the other piece that we also don't often talk about is the costs that Mr. Garner had to pay, in order to be a plaintiff in this case, right? Someone who was already on living within, the margins, right? To then be a part of this case where you're essentially blowing up, your life even more. Just sort of like reading some of the things about, Mr. Garner, someone who had often struggled with, employment, often struggled, with securing housing, all of these things that, the compacted trauma. And so I think that there are also some lessons that I think that folks who are working in movement spaces are kind of learning now around sort of how do you think about the trauma that impacts the work that we're doing and creating, and what does that look like for the people that we are working for, as well, and how do we start to like make sure that we're unpacking those pieces as we try to support them with the legal support and remedies that we are also like working towards.
So I'm glad that you all are not bifurcating the issues of race and sexual orientation, because I tell people at work all the time, I don't get to decide when I'm Black and when I'm gay because I'm always both simultaneously. But let's bring race front and center. And Eric, I want to stick with you for this one. How has the case impacted the movement for racial justice? And especially, let's talk about Black legal professionals. That's our community.
Absolutely. And so, I mean, Lawrence v. Texas is in a lot of ways, I think what we've, kind of named here, as much about queer identity as much as it is about race and class, because I think class is also like an important part of this. And it shows, really how these things are both important calculations as we're thinking about unpacking, the law, the criminal legal system, and sort of like doing the work that we do. Going back to Brianna, I think sort of like the facts of the case, we remember, Nneka talked about the call to the police was not to report, sex. It was a call about a gun crime. Specifically, they talk about a Black man going crazy with a gun in Lawrence's apartment. And so we know this as sort of a familiar trope, that happens within our community that often ends with deadly consequences. And so I think, sometimes that part of the Lawrence legacy is often not talked about. I think additionally, wherever queer people have been discriminated against, those are folks who are often at the lowest end of both the economic scale, and folks who are most hardly hit by a lot of sort of the structural issues that are happening. And most of the times these are Black people, right? So when we think about, Stonewall, again, those were folks who were from the economic and social margins, who were vulnerable and often considered undefendable against police harassment. And so I think, again, we see this in Lawrence, police coming into, this community that was not, the nicer part of Houston, and arresting these two men who probably didn't have access to a lot of the resources. And so I think that it's really important, for us as Black legal professionals to always have a racial justice analysis and lens to the work that we're doing, that we have an analysis that is about class and economics, because those pieces are equally important as all the stuff that we, learn, in law school, right? That we have to really unpack all of those things, I think, in order to like see the real picture, the total picture, in a clearer way.
And Nneka, I want to bring you into this conversation as well. Same question. From your perspective, from where you sit, how has the case impacted the movement for racial justice? And if you can weave in for Black legal professionals as well, or legal professionals of color.
Yeah, I mean, honestly, as I like reflect on what's been said and in my preparations for this panel, it really dawned on me that despite considering myself, pretty well versed and pretty well educated, especially about queer issues and queer history, I had no idea that Garner was a Black man. I had no idea that there had been a racial justice element to this case. And I think that's not a personal failing, but something that's an intentional design of the law school and the systems that intentionally segregate different sectors of history because we're too powerful when we're actually intersectional and combined and working together. It reminds me of every time I go to a conference and they have like affinity breakout groups. Like, do I go to the Black affinity group? Do I go to the queer affinity group? And it really, and again, like the quote from Lawrence Tribe about how this case was the Brown versus Board of Education for the queer community. Well, as a Black queer person, Brown was my Brown versus Board of Education. I don't need a second Brown in my life. This is just Lawrence. And so I think what really stands out to me about this case and like events like this that highlight Garner's Blackness is that Black people have always been in the fight, whether in the shadows and pushed out of the limelight or front and center in themes like Stonewall, like you mentioned. And I think it shows the importance for us to carry intersectionality in all the work that we do. And I think it's a fine line between tokenization and having an intersectional lens and worldview and approach. But I do think fundamentally, no white gay person ever told me Garner was Black. It took other Black queer people to have that community knowledge and share that community knowledge. And so I think it's important for us to have each other's back and be willing to educate each other and always keep in mind those intersections, because if we don't bring them up, nobody else will.
So let's bring it into the present, 2024. What issues and challenges do LGBTQ plus lawyers of color and law students and other legal professionals still face today? And Nneka, let's turn to you first.
Yeah, I think there's the classic saying of having to work twice as hard to get half as much was absolutely true for me throughout law school and even as a legal professional being Black and queer. There's just so many different axes of oppression that make an already challenging experience of going through law school and finding your footing as a lawyer that much more challenging. And so I think things like systemic racism, this whole new attack on quote unquote critical race theory, attacks on divisive concepts, and all these kind of multi-pronged efforts to weaken the Black voice and the Black community and the queer community and intersectional communities in general. And so I know one thing in the notes was especially talking about the affirmative action case. And I think we're really going to be in an era where diversity is forced to look different. And I think we're going to be in an era where we already, had to do the little diversity statement where we wear our Blackness and our queerness on our sleeve and, beg to the white cishet admissions people to please let us in because we're Black and queer. And I feel like, ironically, that's going to be even more of a burden on Black and queer people and students and lawyers to have to prove that our diversity matters. But it's just going to be more complicated and we won't be able to say it out loud, but it'll still be an implicit requirement that we show why our presence as a diverse voice is important. And so, yeah, I think that's kind of bleak, unfortunately. I think obviously there's always sources of Black joy and queer joy, but I do think times are tough. It's a tough time to be marginalized right now.
Eric, same question to you. Issues and challenges that impact LGBTQ plus lawyers of color and law students and other legal professionals today, right now.
Yeah. Yes, I'm going to plus one everything that Nneka just lifted up. I think the other thing is just sort of like what's happening, broadly politically. I think we'll be more impacted by some of the things that are happening politically than what some other communities will be impacted by. In Georgia, Nneka and I are both Georgia folks. There's a RFRA bill in Georgia, currently. Georgia is a state that, doesn't have a statewide, non-discrimination policy. And so legislation. And so, I think they're sort of like the, kind of specific things that are like very Black and very queer, but then I think they're the sort of like broader things that are also really pressing down on us. That I think that, we also have to think about, how we're able to utilize, our skills as legal professionals to also like push back against some of those things. And so, I think a lot of it is the really bad legislation that's sweeping across, the country, whether it's around, trans rights, whether it is all the stuff that we're seeing in states with critical race theory, And it really will become incumbent upon us in a lot of ways to be the folks who are like thinking about how we address some of those things to make sure that people are like more broadly protected.
And before I turn to you, Brianna, because this discussion has been so rich up until this point, and so I want to bring you in on the same question. But for the audience out there, if you all have any questions that we're able to work into this discussion, please put them in the Q&A, and we'll try to get to them. But Brianna, I do want to get your thoughts on this question. Challenges and issues that LGBTQ plus lawyers of color and law students and other legal professionals still face today.
I feel that LGBTQ lawyers of color struggle with simply deciding whether to be visible and how to be visible. I think we have to say the quiet part out loud. It's still very dangerous. It's still very scary. There's some community, but there is not a lot of community, and folks are scared. Though I work for org in Seattle, I work there remotely. I'm local to Houston. I live in Houston. And something I have to worry about, something I constantly contend is, for me, do I, as a Black trans woman, want to, do I want to be openly a Black trans woman attorney in Houston? And I'm licensed in Texas, but the climate is scary right now. And as somebody that has been publicly visible before, I'm now negotiating what feels comfortable for me, because I know only one other Black trans woman attorney that's practicing. So there's not a lot of community, and I think we have to start to have more honest conversations just about how scary the state of the world is, the state of the country is, and to give people space to speak about their hesitations, about their anxieties, and also to have grace for some people, because everybody's not going to be at the point where they can be public and be out, and folks have many different reasons. And I think it's very important for us to continue to build our community and to continue to build our spaces. And that's why I choose to participate where I can and what feels safe for me, but also continuing to have grace for folks, because it's not getting safer. So I just think we have to have space for people are struggling with whether to be visible, because there are real consequences for folks.
Thanks for sharing that. And it also sounds like we perhaps need more allyship. So turning to allyship, and just to level the playing field, I use the word allyship in the broadest form possible. So I don't just mean straight cisgender white people being allies, but I mean other LGBTQ plus people being allies for each other, Black people being allies for LGBTQ plus people, so on and so forth. You get the picture. My question is, what actions can our allies in legal education and the profession take to stand in solidarity with us? And Nneka, if I can turn to you first.
Yeah, I think something that motivates a lot of people who, especially pursuing public interest work or social justice work or volunteer, what have you, they want to be a voice for the voiceless. They want to, let the unheard, let their voice sing. But sometimes you don't need to be their voice. You just need to pass the mic. People can speak for themselves. People know their own lived experiences better than you do. If they don't want to speak, absolutely be a mouthpiece for them. But I think fundamentally, a lot of the times our issues get presented through well-meaning allies rather than allies just simply letting us voice our own big opinions. And so I think, for example, if you get invited to a panel, and you are a cishet white guy, hey, maybe there's a Black woman you can talk to, maybe there's a queer person you can talk to, maybe there's someone other than just a majoritarian identity that you can incorporate into your board or into your panel or into your working group. And again, it's not, it's not about tokenization, it's about intentional and thoughtful intersectionality that allows people to bring their full lived experiences in a way that feels comfortable for them. Like Brianna said, it's not safe to be visibly queer or trans right now. And so it's not about outing people or forcing people to be the voice for their community or the voice for their issues, but empowering people and giving people the autonomy to have a voice if they so choose.
Eric, other thoughts about our allies in legal education and the profession and what they can do to support us?
Yeah, I mean, I think this is kind of actually a good like example of like what good allyship, looks like. I think that in 2021, when conversations started about, there being a gap in terms of there being a space for Black legal professionals, Black queer legal professionals to like just be with each other. I think the LGBTQ bar was responsive to that, and so, and responsive in a way that, wasn't tokenizing, that also like was, very considerate and like brought the necessary people on board to be the thought leaders around what it looks like. And, they provided the container for it. I think several years later, there's now, a scholarship that will happen. We get together, once a year at the conference to just be in space, with each other, right? And so I think those are some good ways that allyship shows up. I think the other space, and Brianna, I think you mentioned this a little bit, is just, I think the acknowledgement of, racism and anti-Black sentiment within the LGBTQ community. I think acknowledging like that is actually like a thing that happens, I think goes a long way in terms of, there being sort of like real allyship, and allows for us to be in a space where we can really like trust each other. But I think that acknowledgement also like has to happen in order for us to do some of the reparative work that I think needs to happen too.
Brianna, you got us sort of started and led into Eric's response. Would you like to add in your thoughts on allyship?
I just feel that it kind of alludes to something somebody said before. We need more cis het folks. We need more white folks to show up to our events and to show interest in our events. Like it shouldn't just be, it should be us creating spaces for us, but after a certain time, it's us preaching to the choir. And we need folk. For the LGBT part, we need white or non-Black LGBT folks to join in on the conversation. I'm also part of the National Bar Association LGBT division. We need straight folks. We need cisgender folks to show up to our meetings, to show up to our events, because at some point, if we're going to be having these cross conversations, we need folks not only to care when something is happening, but to also care when we're organizing and bring attention and bring awareness to the work that we are doing. Because though we deal with a lot, we're not a helpless community. We're smart, we're ingenious, and we know how to collaborate and work together. And we need more people from outside of our communities to actually show initiative and commune with us when appropriate, because every conversation, every space is not going to be for you, but there are a lot of things that folks can do, because no longer should people be saying, well, I didn't know, or I wasn't aware. No, you didn't want to know. You didn't want to know. You didn't want to be connected to folks. You wanted to kind of be, live life as you known it. And people have got to put in more of the effort to make genuine and authentic connections to our communities and don't just show up when something bad happens as well, like to really be in relationship. And I know I'm a part of many things, and we're creating events, we're doing stuff, and we need support outside of our identified communities to be there.
Before we turn to my last question for closing thoughts and then some housekeeping matters, there is a question from the audience, and specifically from August Barnett, who is a 2L at New England Law. And I will just read it verbatim. Thank you for all of your time and for sharing your experiences and insight. How do you pair pride with this topic, specifically the need or want of Black pride during those months? What types of events, themes, programming have you introduced to either edify the community or push the needle towards more empowerment, especially economic, educational, etc.? And also, how can I help? That's how can August help? Who wants to take that one?
So I think if is the question specifically around how the LGBTQ bar approaches pride, or are we talking pride more broadly?
I think August is talking more broadly.
Yeah, I mean, I think it's one of those. I think this is like kind of perfectly paired with some of the allyship conversation that we're having. You know, in Atlanta, we actually have a Black pride, and then there's a more, general pride that happens. And the reason that the two prides exist is in large part because there's been,
Racism, you can say it.
historically, yeah, yes. And so, I think until we're able to really address the racism, the anti-Blackness, that, we feel as queer people in broader queer spaces, then I think it's one of those things that we just have to continue to work towards.
So as we wrap up, I'm curious about each of your closing thoughts on the legacy of Tyrone Gardner and also what's next for our community, whether it's the queer people of color community or specifically lawyers. And Nneka, why don't you get us started?
Sure. I was hoping for an opportunity to get on a slight soapbox, which is just that the transgender community is point blank period under attack, and we need allyship, we need support, we need resources, and we need people talking about us, uplifting us, not only when we're being harassed or assaulted or God forbid murdered, but uplifting our joy in our creation as well. And I think now more than ever is a time for people to be committed to queer and trans liberation. And what's next for our community is, I think, the fight about trans liberation and transgender rights. Here at the ACLU of Georgia, we have litigation about bans on gender affirming care for trans youth. And we're really keeping an eye on all the anti-LGBTQ and anti-trans bills getting passed this session. So I think what's next for our community is unfortunately a lot of fights ahead. I feel like as progress moves forward, there's always regressive trying to take us back. So doing our best to outshine and overpower those social regressives that want to take us back to pre-Obergefell, pre-Bowers, pre-Lawrence, pre-everything cases. And I think kind of as been talked about, what's next for the community is continuing to build community, continuing to have these spaces where our stories can be told, continuing to highlight and prioritize Black experiences, and continuing to have solidarity with one another.
Brianna, closing thoughts.
Closing thoughts. Well, what's next? I just want to piggyback off of what NECA said. Everybody needs to be concerned about anti-transness and anti-trans laws. Also, at Lavender Rights Project, we wholeheartedly believe that Black trans folks have the skills, have the wherewithal to lead these movements. Even though oftentimes we are thwarted from leadership or we are our leadership is undermined, and creating platforms and creating spaces for Black trans folks to lead as we have always led, and to make sure that we are just not on the table, that we have a seat at the table, and also that we're working to tear the table down. And also being like a former impact litigation lawyer, that we should be concerned about the whole lives of the people that we represent in these particular type of cases. Like, we should always be checking in with ourselves to make sure that we are not exploiting people, because it's a fine line between wanting to save somebody and ending up exploiting them. And once the media attention is gone, once the notoriety and stuff dissipates from these cases, these are still real people at the end of the day that have real lives. And we have to be invested in setting up systems of care for people. Also knowing that it doesn't have to look one way. There are multiple ways that this can be achieved, and this is where we have to get creative. But at the end of the day, these are just not abstract people in a book. These are people with real lives that have pain but also have joy. And we need to be concerned about holistic approaches to making sure that our plaintiffs are able to live in the world that we all hope to live in, and they're able to reap the benefits of putting themselves out there in this type of way.
And Eric, a former Tyrone Garner Fellow, your closing thoughts on the legacy of Tyrone Garner and what's next for our community?
Yeah, I think, one, we want to keep the memory of Tyrone Garner alive. Tyrone Garner died 3 years following the decision at 39. He didn't have a perfect narrative. Like Marsha P. Johnson, he's, not gotten his due. But, I definitely see him as a hero. And, we're often told that, if your story isn't perfect, it can't have impact. So when I think about Mr. Garner, I think about a lot of the Black queer men that I've known. He feels very familiar. I feel like his legacy, has guided and impacted the work that I do and how I think about doing that work. And that's work that is, has a strong racial equity lens. That's work that is community centered. And it's work that seeks to get at the root cause of some of the issues that we're looking to address. So his legacy really makes me hopeful about, the young people that we see at the Capitol, showing up, for their communities, putting themselves on the line to really think about what our liberation looks like. I think that we have a lot of fights ahead of us. I think that we have to do that, in a way that is like collective. How do we build bigger tents? But also, how do we change hearts and minds? We can change legislation all day, every day, but we also have to change hearts and minds. And so, what's the work that is also happening through some of the relationships that we're building through our allyship, through building, larger tents that lead us there. Georgia is not unlike other states who are dealing with the onslaught of really bad anti-LGBTQ, anti-trans legislation. And so I think that whatever we can do, whatever your part looks like, if that's, writing a check, if that's showing up to a lobby day or to a protest. We need all of our collective efforts to really think about what our greater liberation looks like. And so I think that's what I'm thinking about as we think about the legacy of Tyrone Garner.
And Eric, while you have the virtual microphone, I think you've got some announcements as well, right?
Yes, a couple of announcements. One is the National Bar Association LGBTQ division. Both Brianna and I serve on the board. We're having a membership meeting on March 27th. We'll make sure that information gets sent out to the listserv. But again, as we sort of think about, how we build our collective power, this is a way for us to think about doing that. The other thing is, this year we were able to launch a scholarship thanks to the partnership with the National LGBTQ Bar Association, and it is called the Garner Scholarship. And so we are looking to give $2,500 scholarships to as many Black queer students as possible to be able to utilize those dollars in whatever way, they see fit. I think that we understand the challenges of being, law students of color. And, $2,500 could help you with your bar fees or whatever you need. And so as a part of the commitment and allyship, with the National LGBTQ Bar Association, we are raising funds for that scholarship as well. And so I think we're going to probably drop a link into the chat. And so please, 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 please donate to that. We want to be able to give out as many scholarships as possible. And I think that's all that I have.
Well, please join me, everyone, in thanking our panelists, Nneka, Eric, and Brianna. And as I mentioned, this program has been presented by the Black LGBTQ+ Legal Professionals Caucus. If you're interested in joining the caucus, email us at info@lgbtqbar.org. Once again, the email address is info@lgbtqbar.org. We also invite you to join us in Washington, D.C. this year at this year's Lavender Law Conference and Career Fair. It's all going down from August 7th through 9th. And if you're at the conference this year, there will be a special dinner for caucus members. It's going to be on Thursday night, so that's August 8th. Once again, thanks to our panelists. Thanks to each of you for joining us. Happy Black History Month, and be safe, everyone.